Here's a myth in the Darlie Routier case that supporters still run with today. Not allowed at Darlie's trial was a police surveillance video showing a solemn prayer service. Police had bugged the gravesite without a court order, so it could not be shown. Police officers took the fifth and refused to answer any questions about the case. Here we have Jimmy Patterson, who was a lieutenant, retired this year. David Neighbors, Dean Poos. Not sure who these other two are, but they're the members of these two were on the scene. This gentleman is the one who gave the press conference. We believe that the man Darlie Routier described never existed. That's him. On June 14th, 8 days after the murders, there was a graveside prayer service for Devin and Damon prior to the birthday party. Officers placed a microphone nearby to monitor what was said. This is an investigative tool that has been used for decades by law enforcement because guilt-ridden perpetrators may confess at their victim's grave. Police also routinely attend victims' funerals to watch for suspicious activity. In this case, the tapes yielded no exculpatory evidence. Nonetheless, Greg Davis turned them over to the defense before the trial began. It was in discovery. He had to turn it in. Toward the end of the defense's case, Doug Mulder called Jim Patterson to the stand. Detectives Patterson and Froush had authorized the placement of the microphone in the cemetery. Mulder accused Patterson of committing a federal felony, a conspiracy plot, and told the detective he was going to jail. It was a last-ditch effort to save his case because Mulder knew he was losing and losing badly. From the transcript: Patterson, if you're saying that I violated some state or federal law, then I'm not going to answer it until I have legal counsel. Mulder: well, I suspect you better get legal counsel then, because I'm suggesting to you that that is exactly what you did. So Patterson and Froush followed Mulder's advice. They retained attorneys who advised them to invoke their Fifth Amendment privilege against self-crimination. Mulder's strategy, of course, was to prejudice the jury by forcing the officers to repeatedly take the fifth. The court, however, recognized that this was a legal issue beyond the scope of the trial, meaning it had nothing to do with the crime that was being discussed, and ruled that the detectives could not be questioned about the tapes. Now this is Judge Toll, not Judge Francis. It's Judge Toll. Judge Francis is the one that had Alzheimer's. The court holds this improper impeachment of evidence. The officer's actions do not reflect upon his character for truthfulness or untruthfulness regarding his testimony in this case. Any recordings made were not admitted as evidence, nor was there an attempt to admit them as evidence. It means the defense had the tapes through discovery and they didn't put it in as evidence. The defense didn't do that. For these reasons, I find that the potential prejudice outweighs the probative value of this evidence, and the defense is ordered not to go into it. Remarkably, Greg Davis told the court that although the defense had not entered the tapes into evidence, that he had no problem if they wanted to show them to the jury. Davis: I don't think there's any problem with it, Mr. Mosty or Mr. Mulder offering that videotape. I mean, whatever was recorded out there, we certainly don't have a problem with them doing that. Because Davis had already saw the tape. There was nothing on there showing Darlie grieving. There was no confession. That tape was 14 hours long. And of the transcripts from volume 43, sections 4406 through 4407. Additionally, Judge Toll's ruling did not prevent the defense from questioning the officers about any other aspects of the case, as long as they avoided reference to the legality or illegality of the graveside monitoring. Mr. Pickerel, the judge: Your Honor, Detective Frost would assert his Fifth Amendment right. Judge Toll: Concerning the testimony as regards to the recording devices or the microphones at the cemetery, and only regards to that, concerning that portion, is that correct? Mr. Pickerel: That is correct, Your Honor. You can find that in volume 43 of the trial transcript, sections 4406 and 4407. The defense declined to show the tapes to the jury. Why they did not is open to speculation, but it is certainly not because they were prevented from doing so. Both sides acknowledged that the tapes were of poor quality, so perhaps nothing was to be gained by admitting them into evidence in the first place. I believe they weren't shown because Mulder's sole objective all along was to force the officers to repeatedly plead the Fifth, thereby implying that they had something to hide, that they were out to frame Darlie. When this strategy backfired, there was no point in pursuing the tapes any further. It's also possible that the tapes did not show a grieving Darlie, as supporters have continued. That's why we still haven't seen it to this day. It's in discovery. Darlie Key claims to have it. They say, oh, they didn't show the tape where she's falling down on the ground and couldn't control herself and just crying and grieving appropriately. Darlie Key has that tape. Whatever Mulder's motivation was, he did not show them, nor did he question the officers any further, even though he could have. Darlie Key and Darin Routier subsequently sued the City of Rowlett, Patterson, and Froush, and the Assistant District Attorney for invasion of privacy and search or seizure violations. On May 28, 2001, the Fifth Circuit Court of Appeals ruled against them, stating there was no expectation of privacy in a publicly accessible cemetery. The court ruled that the two plaintiffs had no expectation of privacy in a publicly accessible cemetery. In 1996, Darlie Key and Darin Routier, the grandmother and father, respectively, attended a gravesite memorial service for Damon and Devin Routier, two boys murdered in Rowlett, Texas. As part of the official investigation of the murders, police placed an electronic surveillance wiretap in an urn near the graves in case the killer made a coffin-side confession. Police recorded both audio and video at the gravesite. Upon learning of the bugs, Key and Routier sued the City of Rowlett for search and seizure violations and invasion of privacy. They also sought damages under the Federal Wiretap Act, which prohibits intercepting oral communications without a warrant. The Federal District Court granted summary judgment for the city and ruled that Key and Routier had no expectation of privacy when they spoke at the funeral. The district also ruled that the police had qualified immunity for their actions. In determining whether Key or Routier had an expectation of privacy while at the gravesite, the Fifth Circuit examined such factors as how loudly they spoke, the proximity or potential of others to overhear them, the potential for their conversation to be reported, and Key and Routier had done anything Key and Routier had done to keep their conversation private. It wasn't very private because they invited the media in. See, that's two different tapes. A lot of times people get the tapes confused. They invited the media in KXAX with Joe Munoz. So if they wanted it to be private, then why would you bring the news into it? The appellate court ruled that Key and Routier failed to come forward with sufficient specific evidence that they expected their communications to be private. Key and Routier adduced no evidence regarding the context of the communications that they now seek to characterize as private. Judge Carolyn King, probably had Alzheimer's, said in the opinion, they do not argue that the prayers were hushed or their voices were modulated to protect their conversations from uninvited ears, and they have provided no information about the tone, volume, or audibility of the private communications directed towards the graves. The court was also concerned that Key and Routier failed to take affirmative steps to preserve their privacy, such as making the service private or excluding people. The conclusion. Darlie supporters have continually distorted and misrepresented the facts surrounding this incident. Patterson and Froush were being falsely accused of breaking state and federal laws. It was their constitutional right to plead the Fifth until the issue could be resolved post-trial. The defense was not prevented in any way, shape, or form from questioning these officers regarding other aspects of the case. And finally, the defense had free rein to show the video and audio tapes, despite the fact that they had never entered them into evidence. An almost constant refrain from supporters is, Patterson took the Fifth. He must have had something to hide. To this day, they're doing that. What the same supporters are loath to admit is that Darlie herself took the Fifth at a pretrial custody hearing. From the Dallas Morning News, July 4th, 1996, by Mike Sull, Miss Routier, who sat in the witness stand Wednesday for the first time since her June 18th arrest, invoked her Fifth Amendment right not to incriminate herself before taking the stand. Miss Routier's attorneys instructed her not to answer any questions. These are excerpts from Darlie Routier Fact or Fiction, done by Mary Moody. These come directly from the court trial transcripts.